everybody. How are you doing on this fine Tuesday? I am doing quite well. Um, a bunch of y'all have requested that I talk about the guardianship court documents for the Houston Texans owner. Full disclosure, I do not know anything about the Houston Texans, in particular, their owner. I mean, I didn't even know it was a lady till today, for example, or yesterday, actually. But I do talk about guardianships. I do talk about conservatorships a lot on this channel. So it usually doesn't take me very long to get my hands around a story. But that being said, I don't know every single thing about this family, like I said. So just bear that in mind. So, where I want to start, and shout out to everyone in the chat. Okay. I saw something about this. Somebody said, McNair Jr. gives me Haley Joe Osmond from like that. Like, I don't know. The vibes and all that. But I want to start here because this is an article that one of my colleagues sent me and figured that would be best place to start, better than, whatever here on this video, because that's where I started in my investigation. So this is kind of like a live investigation a little bit. This is from the Houston Chronicle and it's from just yesterday. It says McNair family court dispute. What is guardianship and how is it different from conservatorship? Okay, right off the bat, it's usually not. Okay. Guardianship is just the word for it in some states, and conservatorship is the word for it in other states. Now, there are a few states where they do have both guardianships and conservatorships. They share, things in common. They also have some differences. Each state is different, but a guardianship and a conservatorship are both reassignment, taking away and reassigning some or all of your rights to another person. That is what it is. Whether it be a guardianship, whether it be a conservatorship, is taking some rights that were supposed to be, fundamental and or inalienable from you and giving them to someone else. And the court is done by, with the force of the state. So that is what a guardianship is. That is what a conservatorship is. They have a little bit of different technicalities, but that is the gist. Okay. So this right here, Houston Texans co-founder and chair, Janice McNair, laughs on the sidelines before a football game against the Tennessee Titans at Nissan Stadium. This is back in 2019. Okay, so here's the article. The fate of the Houston Texans could look much different pending the outcome of Robert Carey McNair Jr.'s legal pursuit of guardianship of his mother and the team's owner, Janice McNair. It's the same person. Here's everything to know about the family's court dispute so far, including the legal ins and outs of Carey, that's the petitioner on the guardianship, including his request. Carey applied for a guardianship of an adult person and estate. So he applied for two separate guardianships, or I don't know, maybe it works as one or whatever in, where are they, Texas? I don't know. But he is applying to be, or to have someone be in control of not only the estate, like what Cher did with her son recently, but also the son, Carey, is trying to get a guardianship of the person. That means he would, or whoever the guardian is appointed, they would be capable, legally allowed to make personal decisions for the owner of the Texans. And once you start seeing this, I mean, it's taking it a bridge farther, because you're not only saying, look, she's a little bit too senile or whatever to be able to run the Texans or make the decisions, the business decisions on the Texans or whatever. But once you start going to guardianships and conservatorships of a person, now you're talking about a whole nother can of worms about somebody's personal day-to-day decisions, like, oh, this hair, like where they live and, if where they can go a lot of times. Sometimes that extends to medical decisions. So just to keep that in mind, he applied for both. The son of Bob and Janice McNair serves as the chairman and CEO of McNair Medical Institute. He also guides the business operations and investments, particularly the acquisition and development of high-yield assets at McNair Interests as the CEO. Okay. So look, I'm glad they did this. Who is Carey McNair? He's the petitioner on the guardianship. He's the one who applied for the guardianship. Now I want to be very careful because I'm not exactly sure if he applied to be the guardian. He may have just applied for a guardianship and to have someone else or an entity or a bank or something applied as the guardian. I don't know who he wants to be the guardian. But here, he did apply for a guardianship to be appointed over his mother and not only over her estate, but her person. He is the chairman of something called McNair Medical Institute, which I don't know what that is. And then he also guides the business operations and investments, particularly the acquisition and development of high yield assets at McNair Interests as the CEO. So he is the CEO of the personal wealth planning machine of this family. And I think I read earlier that just the mom alone, the owner, is worth like $5 billion. Is that what it said? Hold on. McNair. Okay, yeah. I mean, seriously, look at this. Janice McNair is worth 5.6 billion with a B dollars. And I think that might be the highest net worth individual that we have spoken about on this channel, other than perhaps Sumner Redstone, who was the head of the founder and the owner, the sole owner of Viacom. And he had the majority of the decision making power. And he may have been worth more than this. But I mean, the woman's worth $5.6 billion according to the Google. I don't know, how accurate that is, but that's what it says on there. Okay. Now this is going to end up being important right here. The fate of the Houston Texans could look much different. I know we already read that, but this is a big deal. The fact that the fate of the Texans could look more much different, because this is going to come up in some of the court filings. Okay, Carrie, we just established, is the CEO of the McNair Family Financial Fund. Basically, he is the person who guides the business operations and investments of the family's funds. And so him wanting to take control, have, the mother lose her power, in my opinion, is a conflict of interest. And I'm already kind of like, it's not passing the smell test for me. Okay. The one who's running all the assets and everything, it's a conflict of interest because she could be stopping him from making certain calls with this money. She could be standing in his way in some way. These are the things that you have to think about. Now, do I particularly feel sad and sorry for this billionaire with $5.6 billion? I mean, not really as much as I feel for somebody like Amanda Rabb, but at the same time, this woman is one of the most wealthy people I've ever talked about, if not perhaps the wealthiest. And it happened to her. So even if you have all this money, you never have enough money to ensure that your constitutional and fundamental liberties are protected in the land of the free, in the home of the brave, allegedly. Okay. So yes, I do talk about the rich people. Do I personally feel as bad for a Janice McNair as I do for Amanda Rabb? No, I do not. But that being said, I do feel bad when somebody loses their rights. Yes, I do. And I don't know anything about her. She might suck and all that. But even if she does, if it can happen to her, it can happen not only to you, your grandma, anybody, everybody, and nobody's going to care. And then what? You know what I mean? That's why I like to shine a light on these cases with the high profile individuals, because it does show that our system can be used like this against anybody. And just imagine if you had $0, much less 5.6 billion. Okay. So he's like the financial CEO of the family or whatever, the one that applied for the guardianship. Harris County probate court records show that he hopes the court will declare his 87-year-old mother incapacitated and appoint her a guardian. Who are the McNairs? They have owned the Houston Texans football team since 2002. Janice, that's who we're talking about, the proposed conservatee. She took on the role as principal owner. Okay, important. Hello. Principal owner and senior chair of the Texans in 2018 after her husband, Bob McNair, passed away. Okay, so what does Janice has to say? And we do have this court filing, which we can take a look at, or maybe we'll just, get enough here. But Janice opposes the application along with her son, Cal McNair. Now, here is where it gets interesting. And it's kind of given a little bit like succession, with all these family members serving in all these head roles, and now they're getting in fights or whatever. And so I'm kind of glad that show existed because now y'all might be able to understand it a little more. Not like, that, but you know what I mean. Okay. So Janice opposes it along with her other son, Cal. Now, we've been talking about one named Cary, Cary. Now we're talking about Cal. I think his name is like Robert Calhoun McNair, like something, and Cal is for Calhoun, but he goes by Cal. And here comes the drama because he isn't the CEO of the family's trust funds or whatever. No, 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 no. He is the chair and CEO of the Houston Texans. Ooh, wow. Okay. So we have this guy, Cary McNair, who seemingly is trying to get conservator appointed over the estate of a woman who owns the Houston Texans. But the CEO and chair of the Houston Texans is that guy's brother, older brother, I think. And so it's like, hold on. You're going to see, I won't bury the lead. This all ends up at the end of the road where I hate these ads. At the end of the road, it all ends up coming out that oh, I got so distracted. That they're fighting over whether or not to seal these court records, whether or not to seal all of them, any of them. I'm not really exactly sure. We do have some court records, but the actual application for the guardianship, the application that Cary had filled out is sealed temporarily sealed. Now, everybody in the case wants it to be sealed. Janice, the proposed conservatee, she wants it sealed. Cal, the CEO of the Texans, he wants it sealed. And so does Cary, I guess. And so it's temporarily sealed. But here's my opinion on it. This, not one single word of this entire case should be sealed, save except like a social security number and maybe a home address or something. And even then, I'm like, social security, yes. Home, personal cell phone. Beyond that, nothing in this case should be sealed. Absolutely not. We are talking about, first of all, billions of dollars and a highly, highly public family who has thrust themselves, this family has thrust itself, knowing nothing about them, into the public eye because they own a professional NFL football team. They also have thrust themselves into the public eye by simply going to the courthouse to air out their personal family grievances. I want to get this out of the way. If you've been on my channel a while, you already know this is how I feel. But you do not get to take your private family matter from inside the four walls of your house. What did your mom used to tell you when you was a little girl, little boy? What happens in this house stays in the house, right? Everybody got told that. It really doesn't matter like what culture you came from. Maybe your mom said it with a different accent. Maybe your dad said it with a different accent. What happens in the house stays in the house. You don't run and tell people our business. Why? Why not? Now, as an adult, I know why. Because people want to talk about other people's business. People are interested. Now you got all these people talking about you. That made matters worse. Also, sometimes it was like people trying to hide abuse and stuff. I'm not talking about that. If you want your shit to stay in a house, you need to keep it in your house. Okay. When you bring it into the public Walmart, when you're beating your kid in the Walmart, we all see it. When you bring it into a public sphere, you are no longer entitled to keep it as a personal, family, private matter. No, ma'am. Who pays judges? We do with our tax dollars. Who pays to keep the electric running in the courthouse? We do with our tax dollars. Who pays the police to go and arrest people and bring them to court and bring them to the 5150s? We do with our tax dollars. And so, according to the First Amendment of the United States Constitution and the whole rest of the Constitution, we get to know how the public funds are being used, what decisions are being made in the interest of the public, and what they do and the public servants are doing with the money that we are paying to run these institutions. Yes, we have a right to know. And so all this, it's a private family matter thing. Then get your ass back in your house. Get back to the house. Because when you're bringing it to the court, It's not a private, personal, family matter anymore. No, it is not. I am just so sorry. I don't even make the rules, y'all. I'm not in charge. I'm just telling you how it's supposed to work. Okay. Just needs to get that out of the way. Okay. What does Janice McNair say about the guardianship? We just read that. Okay. Lawyers appeared in a Harris County probate court on Tuesday morning. So this is last week, a week ago today. How could the court dispute impact the Houston Texans? Okay, I haven't read this part. Tuesday's hearing, this was a week ago, centered on whether the court would seal the records related to this case. So this was a week ago, they went to court on this. Quote, nobody wants to go to court and nobody wants to have a public hearing in court about whether they have capacity, said Ray Madoff, Boston College Trust and Estate law professor. Okay, we got a law professor commenting, nobody wants to go to court and nobody wants to have a public hearing in court about whether they have capacity. Okay, well, so bad. So what? I hope he's about to say that. Let's see what the rest he says. It would be embarrassing for people. So for this woman, there would be reason why she would not want whatever things people would say about somebody to say that they lack capacity. Sure, I could imagine why she wouldn't want it. Most people that goes to prison don't want to go. Most people that get subpoenaed to court don't want to go. Too bad, so sad. You don't, because you got $5.6 billion, get to change the rules for you. I'm just so sorry, boo. No. By day's end, the outcome of the hearing remained unclear. In Janice McNair's request for the court documents to be sealed, she called Carrie McNair's application part of a family dispute and insisted public disclosure of more details would have a serious impact on the Texans. Okay. So again, I hadn't even read this part of the article, but I knew it was coming because this is about my umpteenth conservatorship I've looked into, and it's always this. It is a family matter. It is a family matter. No, well, it used to be. It used to be when it was in your family, but now y'all brought it all out in front of us. Now we can see it, so now it's our business. You're asking the courts, the public, to get involved. The court is not your private cartel to decide decisions for you. No, it's a public institution. Welcome to it. Welcome. Hi. We've been here the whole time following the rules for the peasants. Okay. She insisted that public disclosure would have a serious impact on the Texans. Good. Because if the Texans are operating right now under false pretenses about the capacity of the owner, it shouldn't be, and they shouldn't be. Am I right or am I right? Should this organization and team be being propped up on false fantasies? Or should the public, the Texans, everybody know what's really going on? If you're keeping something from the public that would seriously impact the Texans, it does make me wonder what that could be. And it makes me wonder if it's nefarious. Just saying. Just what I'm wondering. Okay. It will create a needless and baseless media stir regarding the ownership and direction of the Texans, thereby negatively affecting our employees, business partners, and the team. Instead of this, she should just be motioning to dismiss it based on these grounds, instead of motioning to keep it private from the public, they're in the public institution. And listen, I understand she didn't choose to go to court. It was her son, Carrie, that did file these filings and all of that. But at the same time, this is a very public situation and the public does have a right to know. It's like she's saying it will make the public want to be interested in, and they're going to do what the public does. They're going to exercise their First Amendment right to the press, for example. You see what I mean? She's like saying, I want it sealed because I don't want the public to exercise their rights. Because she knows that's what they're going to do. And, I've been in a defamation case before that was disguised as a temporary restraining order case, and I won. But in that case, the judge in his ruling did say, the mere fact alone that thousands of people are interested in the story and in what That Surprise Witness TV has to say, that indicates a public interest in the information and in the speech and in the case. So the mere fact alone that she's acknowledging that the public would be up in arms, media stir, is her admitting that it's a matter of public interest. And so I feel like she's painted herself into a corner, unfortunately for her. Probably best case scenario is to get that son to drop this application and just figure out on the sidelines what he wants. Negatively affect our employees, our business partners, and the team. So she should maybe step down. I mean, I really don't know. Cal McNair, that's this one right here, he's on the mom's side. He submitted an affidavit and echoed similar sentiments to his mother. So he wants it to be private, closed off from the public, that they are asking to, waste our public money. It's like, can we stop paying tax dollars to this case? Can they just pay for their own private mediator somewhere? The affidavit also accused Carey of using his role as a fiduciary in the family's company, to obtain confidential financial and personal info. Court documents did not reveal Carey's reason for seeking guardianship of the mother, nor his application of guardianship of adult person in estate. Back in December, Judge Jerry, y'all know how to say that name? It's Semino. Judge Jerry Semino got probably Louisiana ties, if I had to guess. It's a very common Louisiana, like Cajun French last name. So back in December, Judge Jerry Semino issued a temporary sealing order. So he temporarily sealed it. He ruled Janice and Cal showed that they would suffer immediate and irreparable harm if the case went public, but it's just temporary. When are they back in court? Next court date is February 9th. These are normally public hearings, but there are reasons why people would prefer privacy. The other thing is the reason that people like these cases about wills and trusts is because they can be quite salacious, and that's why people want to get the record sealed. False. And I'm not going to let this man at Boston College University of Law or whatever lie across the internet. I'm not. ESPN or Houston Chronicle might, but I'm not. That is not true. He said the reason people like these cases about wills and trusts is because they can be quite salacious. False, false, false. The reason people like these cases is because it shows how our institutions operate. The reasons we like these cases is because they are matters of substantial and significant public concern. The highest profile people with the most money who are in charge of the highest levels of institutions, people who own entire teams, entire NFL football teams. That has nothing to do with it being salacious. It has to do with the fact that like billions, probably who knows how many, of dollars in an economy is functioning off of these people. Britney Spears, Bam Margera with the Jackass franchise. That is why we like these cases. I'm not going to let you lie across the internet, Madoff. Okay, we're not reading this. We don't care. Okay. Have the Texans or the NFL responded? Okay. So there's another article here. Let's see. I want to reread it. Texans owner fighting claims she needs guardian. Wait. This is the 49ers. This has nothing to do with a guardianship. Y'all see this? Okay. Fighting efforts by one of her sons to have her declared incapacitated and have a guardian appointed. The news of infighting among family comes as the Texans, who won the AFC South this season, get ready to host the Cleveland Browns on Saturday in their first playoff. Carey filed his application for appointment of guardian in November with the probate court in Harris County, where Houston is located. The application, which details his reasons for seeking to have her declared incapacitated, were sealed last month by a judge. In court documents filed last month, attorneys for Janice, the owner, and her son Cal, who is chairman and CEO of the Texans, said that they were shocked by Carey's drastic and unwarranted measures of alleging his mother is incapacitated, seeking to terminate her rights and appoint himself as her guardian. Okay, yes. Okay, so this, I'm glad we read this because it's showing that it is Carrie who wants to be appointed as guardian, which definitely makes my radar go off. If anybody is appointed guardian, it should not be either one of these sons. It should be somebody else, ideally a legitimately neutral third party. But here's the issue. That's going to be hard to come by. A legitimately neutral third party. It's going to be hard to come by because everybody's got an interest in this. He wants to be appointed himself as guardian to control her personal, financial, and medical decisions. The man is off his rocker. He should have stuck to his state like Cher, for God's sake. This is insidious. Medical decisions he wants to make for this old lady? Please, absolutely not. Are you okay, sir? He might have fallen and bumped his head. Ms. McNair and Cal are firmly against any allegation or implication that she is incapacitated or needs a guardianship. Okay, good. In a 2-page affidavit, Janice, and we do have that, we can look at it, who became the principal owner of the Texans after her husband Bob McNair died in 2018, asked that all court records in the case be sealed to protect her confidential personal, financial, and medical information. No, I do disagree that somebody else should be in charge of her medical decisions. Certainly don't think that should be the case, but I also don't think it should be the case that she gets to be a special snowflake who gets to seal her records when everybody else's damn records just got to be all out here. No, go fight the guardianship system. Nobody's been giving a shit. I'm telling y'all, nobody cares till it happens to them. I bet she might wish that she would have made some noise about the guardianship lobby in the past 5 years. I bet she wishes she would have, because look, and it can happen to anybody. It's not just rich people. I see that comment a lot. Why is it only rich people? It's not. Conservatorship abuse is legalized, slavery. So you can own a person. You can own them. You can send them across the border to Mexico and have them locked up in an annexo for the rest of their life. You can have them locked up in a nursing home. You can lock them up at Bridges to Recovery like Britney Spears' dad did. You can subject them to electroshock therapy. You can do anything. You can sign them up for human experiments. You can experiment on them legally. Yeah. Yeah. So maybe those people that still, your son hasn't come after your estate yet, maybe you should start making a little bit of noise about your local reptiles group. And that is the acronym for them, RPTTLS. Look it up. It's the Conservatorship, Trust and Estate, Law, Lawyer, License, Lobby, something. The people are insidious and rich because they are able to do this. Like, I mean, you only need a couple $1 billion conservatorships before you can do whatever you want for the rest of your life. Think about it. Think about it from the perspective of these people, right? Like people who actually would do it. I know probably most of y'all would. All right. Janice, okay. The details of this family dispute becoming public will have a serious impact on the Texans. Janice, I feel for you, baby. I do. But it's not just a family dispute because y'all brought it into the courthouse. You don't own it, last I checked. We all do. So it's not your family dispute anymore because you took it into the courthouse. Get it out of the courthouse. But I do feel for you and all. I do. It will create a needless and baseless media stir regarding, so there's massive public interest in the matter of public interest. We know, girl. We know. Negatively affecting people. The judge held a hearing Tuesday on the request to seal the records. And on Wednesday, issued an order asking for additional information before making a final ruling. He kept it temporarily sealed in the meantime. So he asked for more info. He wanted to do a little bit of a info gathering before he made a final decision. This is a week ago. I would imagine he would be making the decision on this any moment if he hasn't already. Attorneys for Janice, Cal, and Carrie did not immediately respond. The team has no comment. Okay. So this is where I went today. I went to the, let me see. Hold on. Thank you very much, Samantha, for the super chat. Something smells fishy. Thank you very much, Sheila, for the super chat. I really appreciate it. Member for a month, Tinkle Tits, hit the like button. Yes. Shout out to Rabbit. It is elaborate. It is elaborate. It is elaborate. And I'm telling y'all, this is all just speculation, but this is how my mind operates. Okay. All I can think about is the fact that this man is in charge of the family's money already. Okay. He's the CEO, and it just said whatever it was. He directs or he guides the family's financial, and these people are billionaires. Okay. It's not just a little bit, even if it was just a few $100 million, that is so much more money than I can even fathom ever having access to. Like, billions of dollars the man already seemingly guides in the investments and the high yield returning things. First of all, I am highly, highly curious any of those in which he has additional personal financial stake in, right? Like, I'm just thinking of all the conflicts of interest the man could have. Is this mom and the brothers standing in his way of doing something with this money? Is he power hungry? It's like, at the extreme very least, let's say he really cares about his mom and he really cares about her well-being and all of that, which that in probate court is the number one concern by law, black letter law, statute. The number one concern is the best interest of the proposed conservatee. Just like when you're in family court, the number one concern is the best interest of the children. Who's been to divorce court, custody court, and the best interest of the child, the best interest of that's the same thing in conservatorships. Okay. Okay. So what is in the best interest of the conservatee, the person? Because the whole reason you're taking their rights away is because you're going to do something better for them. And so doing something better for them means you have to have their best interest in mind. Why? Because they don't have their best interest in mind because they're incapacitated according to whoever, right? I don't really like this model. I'm just telling y'all how it's supposed to work. I don't make the rules, I didn't write them. But in this case, let's say Carrie really cared about his mom and he was going to make sure she had everything she needed. He was going to stay home with her and change her diapers and stuff, let's say. He should step down as the CEO, guiding and directing all of the business decisions because he has a conflict of interest. He's making decisions as himself, the CEO of the family's investments, guiding the investments. Think about it if he wasn't in the family. Think about he's just the random CEO, right? The random CEO. He's got those hats on. In the business world, they're always talking about hats. Got to wear a few hats, okay? One hat is he's the son, okay? Take that one off and put it down the street for a second. The other hat he has on is he's directing the financial management of the family's money, okay? He needs to take that hat off if he's going to be the son. Why? Because you can't have the people's financial man. It's a conflict of interest. I don't know how else to explain it. His interest is not aligned with the best interest of the person, of his mother, because all of these financial conflicts exist. Okay. So I pulled this up and it looks like, yeah. So as you could see clear as day from the public website, the probate court in Harris County, there's two cases under the search name for Janice McNair. One is the incapacitated guardianship of herself, right? Janice McNair, somebody's, guardianship. The other one is the estate of her deceased husband. Look, remember we just learned he died in 2018. So applicant became probably, we can look at it. Let's see. I never look at this before, but let me look. Case initiated. Hold on. I just want to figure out what to open. Let me see what the admitted will is. It logged me out. I got to log back in. Okay. So I didn't anticipate this, but I just stumbled across the last will of Robert C. McNair. I'm sure it's redacted to hell. Okay, so I never looked at this, like I said, but my spouse, my children. Now, why do you write a will? You've been on this channel a while. Why do you need a will? Why do you write a will? To keep your assets out of probate. Why? Because if you die intestate with no will, then the court has these pre-prescribed rules that they're going to administer, right? Like state by state, it varies. This is not legal advice. Go get a lawyer, all that. But it'll be like, first person in line to take the inheritance from your estate would be your spouse. If you don't have a spouse, it would go to your kids. If you don't have a kid, it would go to your parent. If you don't have a parent, it would go to your brother, whatever, right? Each state has their different things or whatever. But if you write a will, you can override all of that theoretically, right? You keep it out of the probate court because you don't want the court to decide what to do with your money after you die. And here, people like Janice ain't even getting to decide what to do with their money when they're alive because their money hungry Talon kids are grabbing it from them. And I'm not sympathetic to Janice. Y'all know I'm not. I don't like that she's trying to keep it all secret and private. She knows how courts work. But at the same time, we cannot let people just like lose the right to do what they want to do with the stuff that they have. Like, I don't know. That's my opinion. All right. Here's his will. My spouse, Janice McNair. My children, 4 children, Ruth, Robert, Daniel, and Melissa. If my wife survives me, I give to her. Okay, this is important actually for this case we're talking about. He says, if my wife survives me, which she did, I give to her all of my interest in my wife's retirement plan. So she gets 100% of her retirement plans. Okay, so that goes away. All right. I give all the remainder of my estate to the trustee or trustees acting under an agreement dated March 2008 between my wife and me as grantors and as trustees. Restated contemporaneous will to add. Hold on, let me just read it. RCM. Yeah, that's their trust. So she's the trustee of their family trust, I guess. When did he write this will? Dated when? I give all of the remainder of my estate, including any of the above, gifts that lapse, my residual estate, to the trustees acting under the trust agreement. So I don't know who the trustees under the trust agreement are. Between my wife and me as grantors and as trustees. Okay. This is important. All right. I feel like I'm taking the damn bar exam again, which I passed on the first try. Okay. So he's saying at the time of my death, he's saying, I will give all of the remainder of my estate to the trustee and the trustees under this trust that me and my wife started. So they have a trust. It's listed right here, the RCM JSM trust. Okay. So the wife and the husband, Janice and Robert, they come together. They make a trust to put all their assets in, right? The entirety of this will, he's saying it right now, all the remainder of my estate, everything I own, I want it to go in there. So I imagine it's worth billions of dollars, plural, to say the least. All of it sits in that trust. We have another Britney Spears SJB trust situation. If you are not familiar, I explain, I have visual aids and everything on my other channel. Somebody drop the link if you don't mind in the live chat. But we have another Britney Spears situation. Britney Spears in 2004 put all her money, everything she owned, furs, jewelry, cars, royalty, everything, in a trust called the SJB Revocable Trust 2004 something. 2023, 2021, when Britney was in that conservatorship, they still were trying to get their hands on that trust money. It always comes down to a trust. Bam, they started a trust for him and put his jackass money in it. There's always a trust. Stephen B. Timmer, the trustee, there's a trust, hired me for the trust. In this case, this is the trust we're talking about. All right. The RCM JSM trust. And it's the obviously Janet, whatever, McNair, right? Janice S. McNair. We got the Robert McNair, right? Their trust. And look, the trust agreement dated March 2008 is between my wife, that's Janice, and him as grantors and as trustees. So he's telling us in his will that he and his wife are the trustees of the trust. This was written in 2008. Who knows what could have happened between then? However, we do know that Janice was the trustee of the trust. And we do know that that trust is where Robert left all of his assets. Look, this is a public record. This is straight from the Harris County. Don't you come for me. Look, public record. Okay. I appoint my wife to be the executor of my will and estate. Okay. So if the wife is in charge of if the wife is the executor of the estate and she's incapacitated, guess what? It's going to go to somebody else. Could it be that that somebody else has a conflict of interest in what's truly in the best interest of the physical health of his mother? He's going to be in charge of, how do I know he's not going to pull her off of life support just because? How do I know? We're talking about billions of dollars. I'll tell you one thing. They got people in the trailer park where I'm from that'll kill for about $25. So billions of dollars, people will unplug their mama. Yes, they will. I don't know if he will, but it does happen. I mean, look at these people. Look what they've done for money. Then I appoint Palmetto Trust Company, a Nevada limited liability company, to be independent executor. Okay. So look, you think this is going to happen? No, because he's going to step in and he's going to say, in my opinion, I mean, I can't tell the future, but we have Robert McNair here saying, I appoint Janice to be independent executor of my will and estate. If she does not qualify to serve, which means incapacitated, he say, ew. Does he say, then I appoint my son? Hell no. Hell no. Did he say, then I appoint Carrie? I want Carrie to be in charge. Do y'all think that if the dad would have wanted Carrie to be in charge, he would have put his damn name right here and here? Don't you think? No. He said Palmetto Trust Company. If my wife can't be my executor, then I want Palmetto Trust Company. Y'all think that what's his name? Carrie McNair? Y'all think Carrie McNair is going to honor this? I don't. Fiduciary. No individual fiduciaries shall receive any compensation for serving under my will, but every corporate fiduciary shall be entitled to fair and reasonable compensation. Again, is he going to make the corporate fiduciary into his company or something and start skimming off the top? I don't know. Okay. So let's look at some of these documents right here. Okay. And I will say, I have to give a shout out to the Harris County Probate Court website because documents easy to find, searchable for free by last name. Documents are free. You can view them right on the screen. You don't have to download them. I really appreciate the transparency here. What I don't appreciate is that it is sealed from public view, but I do, on the other hand, appreciate that the judge is only doing it for temporary. He has not made a quick judgment on the situation. He's asked for more information. So I'm crossing my fingers and I'm hoping that the judge tells them the truth and follows the Constitution and tells them the truth and says, you're in a public institution here. Okay. So take it to the private mediator if you don't want your public. Okay. Emergency motion. Let's see if it'll pull up. It's probably gonna make me sign in again. No, it didn't think. Okay, so this is a joint emergency motion for the temporary and permanent sealing of the record. Who filed this is Janice, an alleged incapacitated person, and Cal, the CEO of the Texans. Janice and interested party Daniel Calhoun McNair. Okay, so Daniel must be the second one. He's the younger brother, and the older one must be the one in charge of the assets because his name is, I think, Robert Carey. Actually, don't know. Move this court to seal records in the above entitled case, specifically Movants ask the court to 1, immediately enter a temporary order under Texas rule sealing the court records, including all present and future filings. Well, that didn't happen because there's a lot of filings that we can see. 2, set a date and time for hearing on the request that the records be permanently sealed so that they may give the public at least 14 days of such ruling. And number 3, they're asking after the notice and hearing enter, they want the judge to enter an order permanently sealing the records. And they would show the court as follows. Background. This guardianship proceeding commenced on November 27th, 2023, when Robert Carey McNair, that's Carey, filed his application for appointment of permanent guardian of the person and the estate of Janice McNair. As stated in his application, Carey and Cal are Janice's adult sons. Carrie filed the application without the knowledge or input of Miss McNair or Cal, who are shocked at Carrie's drastic and unwarranted measures of alleging his mother is incapacitated, seeking to terminate her rights and appoint himself as her guardian to control her personal, financial, and medical decisions. We already read that part in another article or whatever, but he wants to be the guardian. This is like control freak. Like, has anyone ever told the man no? Has anyone ever told this man no? Because the bold-faced, unmitigated audacity. I can't even imagine applying for a conservatorship or something over one of my parents without talking to my siblings first. And it just goes to show that money is the root of all evil and it corrupts. Yes, it does. They will stab their own family members. The woman gave birth to him. Right in the back. Right in the back. Right in the back. He wants to be the person to be making personal, financial, and medical decisions. Again, I think the man's going to pull her off life support. I really do. That's my opinion. I can't tell the future. I have no idea. I have no way to know. Miss McNair and Cal are firm. That's the CEO of the Texans. Are firmly against any allegation or implication that Janice is incapacitated or needs a guardianship. Carrie publicly filed the application, which includes Miss McNair's confidential medical information, such as her doctor's information, potential medical appointments, her medical power of attorney, and her statutory durable power of attorney. So it was like he was just spilling all the tea. The application includes Miss McNair and Cal's confidential financial information. So it also has financial info in it. Further, the application includes home addresses, and beyond the application, move-ins will be contesting the guardianship application and expect that the ensuing litigation will involve filings and testimony related to Ms. McNair's medical information, financial interests and assets, and Cal's information and assets, and details of private family relationships that does not belong in the public record. Sorry, you're wrong about that. It does, because courts are a public institution funded by public dollars. If you want to settle this privately, please hire a private mediator. One more time, Cal. If you want to settle it privately, please hire a private mediator. You are in the public domain, sir. Thank you. These people are just too used to being able to sweep stuff under the rug because they got $5.6 billion. Okay. No. You're in the public courthouse. It don't belong to you. Ain't your private courthouse. We got to tell these people. Please don't send any hate to anyone mentioned here. Request for permanent sealing order. Okay, found this matter. Presumption of openness can be overcome if it has a serious, substantial, specific interest in sealing the record. So they're giving the test for when you can steal the public's right to see a public record. In determining whether the court records should be sealed, the court is to balance the public's interest in open court proceedings against the party's personal or proprietary interests. Move-ins here we meet the requirements, and we're going to give proof. That will be held, filed in the records, presumably will contain confidential information, medical history, financial information, personal information, other people's financial information in the family, relationships among members of the family. Move-ins' interests in safeguarding their confidential information clearly outweighs the presumption of openness. I don't know if it's clear. Who are the lawyers on this case? They don't have to say it on here. Okay. They have ownership interest and senior management positions with the Houston Texans NFL franchise. Then the Houston Texans should file a trade secret or confident. They should file that. It shouldn't be on the grounds that it's family information. But you see this? You see what I mean? How the goalpost moved, pun intended? It used to be because it was a private family matter. Now they have significant and substantial interests in a team that has, I don't know, like $1 billion franchise or something crazy. Like, is it a private family matter or are they extreme public figures? Like, you have to take a side. This is a little bit both sides of your mouth, Cal. Ownership in the Houston Texans. The details of the family dispute becoming public will have an impact on Movement's ability to conduct business, as it would create a needless, baseless media stir regarding the ownership and direction of the Houston Texans, affecting employees and business partners of the Houston Texans. That's not a reason to keep a conservatorship filing from the public. No, it's not. We have a right to know how the courts are making decisions in these multi-million, dare I say billion-dollar estates. Okay. We have a right to know. Yes, we do. We have a right to know how the Texans business is going to be affected. Yes, we do, because you brought it into the public domain. Yes, you did. Sealing the records will have no probable adverse effect. Yes, it will. Yes, it will, for the reasons I just outlined. It's aggravating me. I want to be on these people's side, but I can't be on their side with the anti-transparency they're trying to do just because they have money. No, everybody else who gets dragged through the probate court has to deal with this. And it should be equally applied, just like the 14th Amendment says, until these rich people start to lash back out at the conservatorship lobby. Nobody says anything till it happens to them. Then they just want a special snowflake award. They just want a special snowflake treatment in the court, instead of saying, what the live in a world where any Tom, Dick, and Harry can just take away someone's rights. Shouldn't we have protections in place that keep our mothers from having their medical business dragged through that's what they should be doing. And these people have enough money to make it happen. They have enough influence and they have enough power to make it happen. So let's get to it. Who's the next owner that's going to do it before this happens to you? Hit me up. thatsurprisewitness@gmail.com. None of the information can be shown to have any bearing. Okay, I disagree. Request for the temporary. Okay, so I just wanted to make sure there was nothing else of use here. So here's David's affidavit, or Cal, the owner of the CEO of the Texans. My name is Cal. I have reviewed the application for appointment of permanent guardian of the person and estate of my mom, filed by my brother, Carrie, seeking to limit or terminate my mom's rights and appoint himself as the guardian of her estate and person. I've also reviewed the emergency motion for temporary and permanent sealing of the record that I am filing together with my mother, Janice. He says I also have personal knowledge of the facts. The application for the conservatorship contains now this is Cal talking. He's saying this thing my brother Carrie filed has my confidential personal and financial information. Specifically, the application includes allegations regarding my role as my mother's agent under her medical power of attorney, and confidential financial information regarding business transactions between myself and my mother, Janice. Okay. So he gave it away. This is kind of silly, Cal. Cal told us one of the things he didn't want public. He's the one who made it public. Look at this. The application contains information and allegations regarding my role as my mother's agent under her medical power of attorney. So Cal is telling us the mom trusted him to make him the medical power of attorney. That's the mama's boy over there. The mom trusted Cal to be her power of attorney. And Carrie is saying, no, I'm going to make some allegations on that. I should be her power of attorney. And if I'm looking at who the mom is actually siding with here, it looks like I'm going to be more likely to believe Cal than Carrie. Carrie is the CEO of McNair Interests Limited, which is a family office that manages many of the confidential financial dealings of the family, which I already explained to y'all, including those of Janice and Cal. Ms. McNair owns a direct interest in the general partner of McNair Interests Limited, and I own a beneficiary interest through trust for my benefit. Okay. So McNair Interests Limited is a family office. It's a fund. It's an investment fund that's privately run, and the CEO is Carrie. Okay. Carrie's also trying to put his mom in a conservatorship, but we do get a little bit more insight into Carrie's financial conflicts of interest that I suspected earlier and now have proof of, like this ain't my 47th guardianship. They always do the same thing. It does make me upset. It does. It really does. Because it could happen to me. It could happen to you. It could happen to any of us. So, Carrie, the CEO of the financial planning thing, look at this. Janice, the person that Carrie is trying to put in a conservatorship, she owns a direct interest in the general partner of the fund. So she owns a direct interest in this fund, pretty much, right? Like she's directly and she's an owner of it. Cal owns a beneficiary interest, which means he is named as a trustee on the trust. He's named as an inheritor or an heir on this thing and a trustee. Who knows what else? But he's telling you beneficial interest. So he's not a direct owner, but he has an interest in, his inheritance, pretty much. I believe Carrie obtained our confidential financial and personal information through these roles as a fiduciary. So now we're getting a little bit more information we're able to put together. Look, he says, Carrie put confidential information in the application for conservatorship. Some of that information includes financial info regarding business transactions between myself and my mom, right? So down here in the next paragraph, he says, I think Carrie got that information, that confidential information about a business transaction between us. I think he was basically abusing his role as CEO of our trust funds and all that, and of the investment of them. He was abusing his role in order to snoop. And now he's in the court trying to use it against us. Carrie's disclosure of the information constitutes a breach of his duties, owed not only to Janice, but to him. Good point. Wow, good point. He's saying, hold on a second. He's the manager of all of our money. He's using his role as a fiduciary. We trusted him. He's using that role to try and take medical control over my mom. Hell no, he violated his duty to us. Good point. I mean, one that I, had already pointed out, but I'm glad he did. I understand that the guardianship proceedings, which I will be participating in to argue and prove that my mother does not need a guardianship, they will involve more detailed filings and testimony related to my personal financial information, as Carrie has made them an issue. My personal and financial information is confidential, and I understand that I have a right to privacy regarding my confidential information. Now, he is right about a lot of this stuff where it's like we don't really supposed to be able to see inside people's bank accounts and stuff like that. But that is what a redaction is for. You see the black bars going through. Sometimes they'll have X's and things on them. That is called redacting. Anything that's personal, confidential financial information can be redacted and we can still see everything filed. These people are trying to seal every and anything permanently so none of we the people ever see what the public institutions did with the public, funds that we are funding them with. On an issue of public interest and concern as well. I mean, it is the Texans we're talking about. I have ownership interest in the Houston Texans NFL franchise, and I am currently serving as Texans chairman and CEO. The details of this family dispute becoming public will have serious impact on the Texans. It will create a needless da-da-da. Okay, we already read that. Immediate and irreparable harm will result if the records continue to be accessible to the public until notice can be posted and a hearing held on the motion. Because my confidential information can be picked up and shared by a third party. Sure, it can be redacted. It could be redacted. And he's saying there's no less restrictive means than sealing the records. And this is where Cal loses his credibility with me because there is. And I just described the less restrictive means, which is to redact the personal information and still have public appraisal of what's going on in the case. They want to just be able to lie. I mean, I'm sorry, that unfortunately seems to be what is going on here. It seems, in my opinion, to be the case that Cal and Janice just want to be able to lie. Because if they were saying something like, my mother's health information should not be subject to the public, please, we don't need everybody knowing what doctor my mom goes to. We don't need everybody knowing her records about her medical. That has nothing to do with the public's interest. That maybe. But he's saying this family matter doesn't need to go public specifically because it's going to affect the business. The only remedy possible is to completely seal the record such that the public doesn't even have any idea what's going on in the case when a hearing's going on. No, you lost your credibility because it's not a personal, private family matter. It's like legitimately like your family owns the Texans. That's like saying like, the governor's conservatorship information shouldn't be public because it's a private family. No, you are a very public family in a very public institution. No, it seems to me they just want to lie about stuff because what is the harm? What is the harm of the public knowing that there was something filed? Again, I want to reiterate. Truly personal, private, confidential information should be redacted. It should be. We don't need to know people's home address or their social security number for the most part. There's exceptions to everything. We don't need to know specifically what medication somebody has taken, exceptions to everything. But in this case, it's kind of like we don't want the public to know the truth because the truth alone, that something was filed in the case, is enough to turn this organization on its head. I think he's arguing more things that makes me feel like the public has more right to know. Who is this Veritas? Thank you so much. Everyone, help me give Veritas Vincent a shout out. They are always supporting the channel so generously, and it just makes me so excited to see these little pop-ups each time. Thanks so much. Okay, so next, let's see what else has been filed here. All right. Affidavit, McNair affidavit. Okay, so here's the one by Janice, her affidavit. I have reviewed the documents. It pretty much says the same thing as the other guys. The application includes allegations regarding my health, mental state and capabilities, finances, doctor, potential medical appointments, medical power of attorney, statutory power of attorney. Carrie is the CEO of McNair Interests, which is a family office that manages many of the confidential financial dealings of the family. I own a direct interest. Cal owns a beneficiary interest. Carrie is, so the dad did. Oh my goodness, the plot thickens. Do y'all remember the Palmetto Trust? That is, oh my goodness. So this plot thickens even more. Conflict of interest is even bigger now. The only thing standing in the way, oh my God, the only thing standing in the way of Carrie McNair controlling his father's estate is Janice McNair. Because his dad's will says, in the event that Janice cannot serve as the trustee of all of my whole estate, every single thing that the rich daddy left behind, if Janice can't be the trustee of that trust and the administrator or executor of my will and executor of my estate, then I want Palmetto Trust to be. Well, who's Palmetto Trust run by? Carrie, the one trying to get the conservatorship. The one trying to get the conservatorship over the mom, trying to get the court to say the mom is incapacitated. If the court does find the mom incapacitated, guess who gets to be in control of the dad's estate? The one applying for the conservatorship. Do y'all see the conflict of interest? Could he be acting in his own interests instead of or in contradiction to his mother's interest? And what did we already establish is the number one concern here? The best interest of the proposed conservatee. I don't make the rules. I didn't write the rules. I'm telling y'all what they are. Carrie is a director of the trust, as are Cal and me. Oh my God, I read too fast. Oh my God. I believe Carrie obtained our information through the roles as fiduciary. Okay. So I was pretty much right. Some of the things technically I said were a little off. Carrie is a director of the trust, and so are Cal and Janice. So if Janice is no longer able to be a director of the trust, it still gives Carrie more power if Janice is knocked down a peg as a director of this trust. This trust is what would be running it. It's two birds, one stone. Because if Janice cannot be, if Janice is incapable legally of being in a contract her own self, she can no longer be the trustee of the trust of hers and her husband, right? That's their whole inheritance. Their whole estate is in that trust, according to the will. Okay. Not only that, if Janice cannot be the trustee or the executor of the estate, then the new person stepping in would be a company called Palmetto Trust Company, right? Who's the directors of the Palmetto Trust Company? Carrie, Cal, and Janice. So if Janice gets knocked out of this, then it increases the percentage of power that Carrie has. Okay. Two birds, one stone. Getting this mom incapacitated helps him enormously financially. Period. That's not speculation. I've read it from the will. Now, is he acting on those interests? Yes, in my opinion. Why? Because he's not stepping down from any of these fiduciary roles saying, I understand and acknowledge the conflict of interest I have, and I love and care about my mother so much, I'm putting her interests first. Someone else can take over this money. Why wouldn't he do that if the real, true, best interest he's looking out for is his mother's? He would indeed put hers above his, but he won't step out of those roles. So it's obvious to me, in my opinion, what's going on here. Okay, understood that the guardianship proceedings will involve my personal information. Application specifically states in paragraph 13 that Carrie intends to disclose my property assets within these proceedings. My personal medical financial info is confidential. I understand I have a right to privacy. Yeah, and that should be redacted. Cal and I have ownership in the Houston Texans franchise. I am the senior chairman of the Texans. So this is the senior leadership of the Texans that Carrie is trying to he's doing this is like Succession, you know? It's just like that show Succession where they're all fighting over the inheritance, the trust. The details of this family dispute becoming public will have a serious impact on the Texans, which they should, because we should know what's going on. It will create a needless and baseless media stir. Immediate and irreparable harm will result if the records continue to be accessible to the public. No less restrictive means. Not really buying that. Okay. So here's the temporary order to seal, the first temporary order to seal. The court finds that they have made a showing of compelling need for a temporary sealing order by demonstrating that they will suffer immediate and irreparable harm in maintaining confidentiality. So the court further orders that any future filing in this case be done under seal until the court hears the motion and rules on the request to place all court records under seal. So he must have decided something. Yeah, look. The court orders that the move-in's motion to permanently seal the court records be heard December 21st. So this already passed. So immediately give the public 14 days notice of the date, time, and place. Okay. So there is a public notice thing. Let's see if we can get into the procedural history here. Order to seal public notice of motion to seal court records. So this is the thing that they had to file by statute to give the public notice that it would be being attempted to be sealed. Post this public notice of motion to seal court records in conjunction with the above referenced contested guardianship proceeding, which concerns Janice as required by rule. A hearing will be held in open court December 21st, 2023. This contested guardianship proceeding involves the request of Robert Carey to be appointed as the guardian of the person and estate. They request all court records in the guardianship proceeding be sealed in order to protect the movement's personal, medical, financial information. Okay. So that was the public notice they had to do. Okay, then when was that filed? On the 5th. So here's the order to seal, amended temporary sealing order. So this one's the same thing, but it's amended. So Janice filed a motion, notice to all parties. A hearing was held on December 5th. After considering the motion, affidavits, declaration, opposition, and arguments of the lawyers, the court finds that movements have made that's Cal and Janice have made a showing of compelling need for a temporary sealing order by demonstrating that they will suffer immediate and irreparable harm. Okay. If the application is made public. Therefore, the court orders that the application and any response or objection are temporarily sealed until the court hears the permanent sealing case arguments. The court orders that future filings in this case be done under seal until the court hears the motion and rules on the request to place all court records under seal. The court orders that the motion and original temporary sealing order entered be unsealed. Okay. This is confusing because it says here at the end of page 1, the court orders any future filing in this case be done under seal until the court hears the motion to place all the records under seal. Okay, so then it says, but this motion and the original temporary sealing order can be unsealed. Okay. So he's saying everything related to sealing the record can be made public. So we can tell the public what we did behind closed doors on why we're keeping them out of it. The only court records in this case that shall be available to the public pending a final order on the motion for permanent sealing of the record shall be the motion, the amended temporary sealing order, the previous temporary sealing order, and the public notice and verified copy of the public notice referred to below. Okay. The court orders that the motion to permanently seal be done on January 9th. So that one already passed too, a week ago. Further, the court orders that move-ins immediately give the public at least 14 days notice. Parties have the appeal as may appear. Okay. So this is kind of like a gag order at the end of it. So since nothing can be said in court, and y'all can't say nothing out of court either, kind of. Jerry Semino. Okay. Let's see. It does seem like, yeah, no. Okay, so the only things that are available to us are things that are in some way, shape, or form connected to the motion to seal the record and the temporary things on that. Now there is one more thing here that is actually, I guess we can read both of them. So this is the second temporary sealing order. This one's from 6 days ago, January 10th, 2024. Janice, hearing was held on December 5th, after which the court granted a temporary motion. On December 21st, a hearing was held to address the potential procedural issues with the sealing order. The court amended the sealing order. Okay, then there was a January 9th hearing a week ago-ish. The court considered the motion for the permanent sealing of the record. Ruth McNair Smith, Palmetto Trust Company, and the Houston Texans joinders. Okay, so people did file joinders, and that's why I was wondering why the Houston Texans hadn't filed anything in this case, and then they have, but it's sealed from us. I don't know why. Because we could take out somebody's personal information with a redaction line. You don't have to seal a whole document or a whole record. No, you don't. And everybody in this case knows it. But they do have affidavits and joinders and things. So Palmetto Trust Company filed a joinder. Ruth McNair filed a joinder. The Texans filed a joinder. Robert Carey filed an opposition to the motion. There were arguments of counsel. There were pleadings on the file, live testimony from Cal and Carey, affidavits from Janice and Cal, declaration from a guy named Jeffrey Pash, and evidence submitted to the court in camera, meaning in court that only the court could see. The court has requested that the parties submit briefing regarding the applicability and or the effect of the Uniform Trade Secrets. Yes, I am such a good non-practicing lawyer. I was like, if this has something to do with a trade secret of the Houston Texans, then the Houston Texans need to be filing this in this case and not people's family members. And it seems as though somebody is arguing the Texas Uniform Trade Secrets Act. With such briefing being due January 22nd. So it's not due yet. The opposition will be due by January 25th. So this is the Houston Texans trying to step in and say, we want to seal some of this for our own reasons. And it has to do with trade secrets. It's going to be the competition is going to be out here and seeing what we're doing and all that. That's a different reason. That is a different reason than it's a private family matter. Okay. And to me, it has a little bit more teeth. It seems a little more good faith. The court orders that the temporary order will stay in effect until Probably, I would assume at least January 25th at the earliest is what I would assume. No, way later than that, because then they're going to have to do a hearing. So maybe February, maybe at the earliest, is when we will be able to see the other documents in this case. And this is how they do in probate court. They just argue and spend attorney fee after attorney fee. The court orders all documents currently under seal remain under seal. The court orders any future filing in this case be done under seal. The only court records in this case are the ones we already mentioned. The court orders that the parties, including those who have appeared, do not. So the gag order. Okay. Signed January 10th. Okay. So there's one more thing here. And this is letter from Paul Dabrowski. I don't know who that is. One of the lawyers. And he sent an email to the judge on January 10th. And the subject is cause number 521-353 McNair. Dear Judge Semino, and this is from whose lawyer? I don't know who Dabrowski is the lawyer for. Does he sign it as? Okay, this is really interesting. We are in these people's emails, but there's a public record. Look, probate court. Oh, yeah, y'all see it. Look, probate court. See that right there? Public record. Dear Judge Semino, on behalf of all parties, thanks for your patience and your email below. Okay, wait, what's the email below? Is it this? January 10th, 2:40 p.m. Yes. Okay, so Judge sent this first email. We'll read it first. Jerry Semino, January 10th, 2024, 2:20 p.m. He says, Mr. Dabrowski, I cannot wait too long. Please email and file any documents seeking to seal the transcript. In my research, including talking to other judges, I have found no authority to seal the transcript of a public hearing. Thank you, Judge Jerry Semino. You are right. There is no authority. There is no authority because it would be stupid to seal the transcript of a public hearing. What do you mean? It's public, it's open to the public, and the public can't have the transcript? Shut up. So the judge basically said that. On behalf of the parties, thank you for your patience and your email below. With respect to your question about requests for formal transcripts of yesterday's hearing, both sides have consulted with each other. I'm about to request this transcript as soon as we get off. Subject to certain exceptions, both sides believe that the transcript can eventually be made public. Please be advised that movements for the sealing order no longer request that the court seal the style of the case or that the existence of the case be sealed, since it has become public knowledge that Carrie has applied for the appointment of an independent guardian over the estate of and the person. Okay, good. All right. This is good. I'm glad to read this. So this appears to be the lawyer for Janice, the proposed conservatee, and Cal, the CEO and chair of the Texans. This is their lawyer writing an email to the judge saying, thank you, Your Honor, and all that. He's saying, my clients, Janice and Cal, are no longer requesting that the court seal what kind of case it is. We wanted Your Honor to keep out that it was a guardianship application, but it's already public. So we're not even trying to get it sealed anymore. We're not, what else? No longer request the court seal the style of case or that the existence of the case be sealed. Because, see, they were trying to hide it from the public altogether. The whole case, they didn't even want the public to know what was going on. And this happens a lot with these famous people, and especially the rich ones. And the judges are just, please hurry up because I might have to do what the Constitution's making me do. Please. The public knows. So the lawyer's like, all right, the jig is up. But he says, my clients still believe that certain portions of the hearing transcript can be redacted or sealed to protect their privacy rights under the Texas law. Respondents disagree, meaning Carrie disagrees. Carrie, weirdly, we found ourselves in a position where we're siding with the proposed conservator, at least on one thing, and that is it should be public. I do think that certain things can be redacted if it's like legitimately private information. But again, if it's public hearing and y'all said it in a public hearing, I don't think it can be redacted. I really don't. I don't know. But Carrie disagrees. If acceptable, both sides will provide briefing on this issue on the same schedule and in combination with the briefing on the trade secrets issue, with move-ins briefing due by the 25th. So he's saying, can we just argue with this on the same date as that trade secrets thing we're going to be arguing about? Also, subject to the court's approval, both sides have agreed on a process for handling any proposed redactions of the transcript. So this is the way they want it to be redacted from, the public. They both agree, both sides agreed. The court will have the hearing transcript finalized and initially distributed on an expedited basis to the lawyers for the parties only. After the lawyers get the transcript, each side can designate the portions that they want redacted, which again is stupid because it was all said in open court publicly. So I really don't think anything should be able to be taken from the public once it was already said in the public forum. I mean, that's the whole point of having a transcript, y'all, is the public can see it. Okay. The ODP will have, so the original designating party. So this is just a process they're trying to go through about how they want to redact stuff that's already supposed to be public and is already public because they already said it in open court. Look, they understand that a request has been made for transcripts of hearings prior to yesterday. The parties agree that the procedures set forth above will apply to all transcripts. Please advise if this is acceptable or if you have any modification. Okay, so somebody has requested these transcripts and the judge brought it up in court and said, hey, so I can't sit forever on this. What do y'all want to do about the transcripts? Please advise if this is acceptable. And they put it in the email. Somebody has requested it. I'm about to go request it too. One last point, Mr. Purse and these people were not included in your email below. I've included them in this email. Thank you for your consideration. Okay. Please do not release the transcripts to the media. The parties are working on a process for, yeah, look at this. Paul Dabrowski, all caps. Please do not release, all bold. Please do not release transcripts to the media. The parties are working on a process. Wanted to inform you all that the transcripts for all hearings have been requested by the Houston Chronicle. Oh my God, that's them. That's these people. The Houston Chronicle. Oh my gosh. Hold on. Where were we? So the judge is like, oh no, the court reporter. I wanted to inform you all that the transcripts in this case for all hearings have been requested by the Houston Chronicle. Judge Semino has looked into whether they can be released to media, and he has advised me they can be. Also, if you have not requested a copy, please let me know and I can send you an invoice. Please let me know if you want all hearings on a particular one. This, I think, is kind of like a little backdoor dealy, in my opinion. I think it's a little backdoor dealy. I think it was improper for the court to send emails to the lawyers in this case, giving them a warning that the press, the First Amendment, freedom of the press, has requested a public document. I don't like it at all, Jerry Semino. I don't like it. The court, isn't this kind of like a weirdly, I don't know, I guess it's not an ex parte communication, but this is not cute to me, Semino. That y'all are giving them a warning so they can get their ducks in a row to hide information from the public that belongs to us. No, absolutely not. I'm not a fan of that, Semino. No, I'm not. However, what I am a fan of is that they can be released. So they need to be released. And that's all. That is all we have so far. Like I have said a couple times here, I will be going to request as myself, I'll be going to request those transcripts. And they're usually hundreds of dollars, so maybe I'll only be able to request one or two, but I'll let y'all know how that goes. That's all I really had for today. I think I made my opinion known pretty well during this, like where I stand on issues. I'm not 100% on either of their sides, because on the one side, I'm kind of with Carrie on the transparency, but on the other side, I'm kind of with not Carrie on him trying to take over his mom's medical rights and also all the financial conflicts of interest that he obviously clearly has. It is not, neither, like I said, one of these sons should be a conservator of this mother. That being said, she has chosen a medical power of attorney already, and it was one of those sons. So who the hell am I to take away her choice? She said she wants Cal to be her medical power of attorney. So I think it should be him, if anything. That's all I really had for today. Thank you to everybody who gave the super chats. Thank you again, Veritas Vincent, for the $199.99 super chat. And I will see y'all very soon. In the meantime, facts ain't defamation. Love you, mean it. Okay, bye.